Hi everyone, this is my week 6 video for Law 301. Today I'm going to be explaining how the US government analyzes the law. So first I'm going to be explaining how one would analyze a statute. Depending on how the statute is laid out, one would break down a statute in one of two ways. Someone would either examine the statute itself or examine the history of the statute. So the first way is to examine the statute itself. This means that a lawyer is going to be examining the actual text of the law. This means going into the statute and finding the section that's labeled legislative findings. This is going to explain the goals or policies that are behind the law. So a statute regulating pollution, the legislative findings section might say that the legislature wants to protect the environment. This is the more straightforward way of examining a statute. However, this doesn't always work, so sometimes advocates have to look into the history behind a statute. They also might do this if the statute doesn't have a citation. This means that an advocate is going to be looking at the social conditions that prompted the statute to pass. This is going to be a way for an advocate to fight on behalf of the client. So for example, if a client technically violates the language of the statute, but it does not conflict with the original purpose behind the law, they might argue that the violation should not result in any liability. So they might have violated the statute, but it doesn't violate the purpose, therefore creating no harm. One might find the history of a statute through committee hearings, debates on the floor of each legislature, or conference reports and statements made by the president or governor. There are more ways to find the history of a statute, but those were the examples provided by the book. So that was the first part of Chapter 6, explaining how one would analyze a statute. Next, we're going to move on to how one would analyze a case. But first, we need to break down what composes a case. The first part is the facts, specifically the facts that each party is disagreeing on. The next section is the procedural history. This section is basically the history of the case in litigation. So the events that have occurred in the lower courts. Next is going to be the questions presented part. These are literally just the questions that the appellant has asked the court to decide. Next is the rule of law section. This is going to be the general legal principle that's applied by the court. So like last week we talked about burglary, and basically we said last week it requires an unlawful entry with the intent to commit a crime. That would be our rule of law. It's the legal rule that we're using to decide the case. The next section applies the law to the facts. So this is going to explain how the facts satisfy or unsatisfy each element of the legal rule. So last week our fact was that Frank entered the house with a gun and a prior intent to hurt Billy. But when applying our rule of law, we had to decide whether Frank formed the intent before or after he entered the house to hurt Billy. So after the court has interpreted the evidence and how it applies to the rule of law, they move on to the holding. This is the court's answer to the legal question. It's whether the rule applied to the specific facts. So in the case from last week, it would be whether Frank committed burglary or not. After the holding, there's the disposition. This is going to be like what happens next because of this decision. Is it affirmed, reversed, remanded? The next section is the dissents and concurrences. This is when the judges speak on behalf of the case. So concurring opinion, a judge is agreeing with the outcome but uses different reasonings. So for instance, a judge might agree that a defendant should lose, but they're going to disagree with the reasonings that brought about that loss. Whereas in a dissenting opinion, a judge disagrees with the majority of the opinion. So using that example, the judge would disagree that the defendant should lose. And in this section, they're going to explain why they think the court is wrong. And then the next section of Chapter 6 talks about stare decisis. Stare decisis basically means to stand by decisions of previous courts. So a decision from one case is going to become binding in a future similar case. This basically just creates consistency and strength in the legal system. Now there are two types of stare decisis. First of all, vertical stare decisis is a relationship between a higher court and a lower court. The lower court is binded by the higher court, meaning they have to follow what the higher court made in a prior decision of a similar case. So for instance, if a Supreme Court made a decision, then a lower court has to abide by whatever that decision is, regardless of their opinion of it. If they don't, the losing party can appeal, or a higher court will reverse the decision. The second type is horizontal stare decisis. So in comparison to vertical stare decisis, where a court must follow a higher court's previous decision, in horizontal stare decisis, a court does not have to. In most cases, a court's still going to follow a previous decision. However, a court may overrule a precedent with sufficient justification. Like I said before, the purpose of doing all of this is to ensure certainty, flexibility, fairness, and efficiency in the legal system. Basically, courts do not always decide cases based on the best result. They're going to decide things with the future in mind. So firstly, when talking about certainty, if courts consistently rule that a certain conduct is wrong, then people are going to know to avoid that conduct. It's going to promote fairness by avoiding biased decision making, and it's going to promote efficiency because courts do not have to rethink decisions every time that they arise. This is going to save a lot of time and resources in the legal field. So the last section analyzes rights and duties, specifically the meaning of rights and duties. A duty requires a person to take or avoid certain actions, where a right is either a permission to do something or something that someone must do for you. And there are 3 characteristics to rights and duties. The first being the people involved. So for instance, between whom is there a relationship? So like, for example, a patient and a physician, a boss and an employee. The next is the subject matter. So what behavior does the right or duty govern? The next is the nature of the relationship. These characteristics are important because they allow lawyers to determine how certain rights and duties will apply to new situations. And that's my week 6 breakdown of legal reasoning.